All right, let's dive in. Today, we're going to tackle Arizona's arson laws. Now, these can be really complex, the stakes are incredibly high, and honestly, the legal definitions can get pretty confusing. Our goal here is to break down all the legal jargon and really explain what these laws actually mean. If you're facing a charge as serious as arson, it can feel completely overwhelming. It's a massive weight on your shoulders. And that's exactly why we're going to walk through this step by step to make sense of what the law is actually saying. Okay, before we get into the nitty-gritty, we have to get this important disclaimer out of the way. What we're talking about today is for educational purposes only. This is not, and I repeat, not a substitute for real legal advice. If you're facing charges, you absolutely need to speak with an experienced Arizona criminal defense lawyer right away. So here's our game plan. First, we're going to define what arson even is under Arizona law. Then we'll get into the three main charges you might face. After that, we'll decode some of those key legal terms that can change everything, look at the potential penalties, answer some really common questions, and then wrap it all up with how you can protect your rights. All right, let's start with the absolute basics. What does it actually take to be considered arson in Arizona? This is the foundation for everything else we're about to cover. So at its heart, the legal definition is pretty straightforward. Arson is all about knowingly and unlawfully damaging something, whether it's a structure or property, by using a fire or an explosion. Now, that word knowingly is super important, and trust me, we're going to circle back to exactly what that means in just a bit. But here's where it gets complicated, because not all arson cases are treated the same. The seriousness of the charge really boils down to two key factors. First, what got damaged? Was it what the law calls an occupied structure, or was it just some other kind of property? And second, what's the dollar value of that property? The answers to those two questions, they change everything. Okay, so let's see how those factors actually translate into the specific charges you could be facing. We're going to look at the three main fire-related offenses, and these run the gamut from a misdemeanor all the way up to a major felony. First up is the big one, arson of an occupied structure. This is the most serious charge of them all simply because it puts human life at risk. And get this, it doesn't even matter if anyone was actually inside. The law just looks at the possibility that someone could have been there. That potential danger is exactly why this is a Class 2 felony.
Okay, next up we have arson of a structure or property. This charge is really focused on the property damage itself, not so much the immediate danger to people. If it's a structure, like a building or a car, it's a Class 4 felony. But if it's other kinds of property, the charge depends on how much it's worth, and that's where we get into a tiered system.
It's all about the value of the property here. If what was damaged is worth more than $1,000, you're looking at a Class 4 felony. If the value is somewhere between $101 and $1,000, it's a Class 5 felony. And for anything valued at $100 or less, it drops down to a Class 1 misdemeanor. Okay, listen up, because this next part is maybe the most crucial and often misunderstood part of this law. The charge is based on the total value of the property itself, not on how much damage was actually done. So let's say you cause a tiny scorch mark on a brand new $10,000 car. The charge isn't based on $50 of paint damage. No way. It's based on the car's entire $10,000 value. And that's what makes it a felony.
And then we have the third charge, which is a little different, reckless burning. This is a lesser charge because it all comes down to your state of mind. The key word here is recklessly, not knowingly. We're not talking about intentionally setting a fire, but about being reckless and causing one. It's still a serious Class 1 misdemeanor, but it's a whole different ballgame from arson.
So, we've been throwing around some pretty specific legal words like knowingly and recklessly. But what do they actually mean in a courtroom? Let's break down the specific vocabulary that can literally make or break a case. This is a huge deal. The difference between these two words is everything. Knowingly means you were aware of what you were doing. Think deliberately lighting a match and tossing it on a puddle of gasoline. Recklessly, on the other hand, means you were aware of a big risk and you just ignored it. Think flicking a lit cigarette out your car window into a field of dry brush. That distinction can be the line between a felony and a misdemeanor. All right, let's talk about another one of those tricky legal phrases, occupied structure. The way the law defines this is probably way broader than you think. It's not just about people being inside at that exact moment. And here's the kicker. Any house or apartment, any dwelling, counts as an occupied structure, even if it's been vacant for years. So what about the word damage? You might think it means the place has to be burned to the ground, right? Wrong. The legal bar for what counts as damage is incredibly low. It really just means any kind of physical impairment. We're talking about something as minor as a little charring, a scorch mark, or even just some smoke stains on a wall. Okay, so we've got the definitions down. We know the charges. But now, let's talk about what this all means in the real world, the consequences. This next part lays out the potential sentences and penalties you could be looking at. And as you can see, the penalties are no joke, and they cover a huge range. On one end, a Class 1 misdemeanor for reckless burning could mean up to 6 months in jail. But at the other extreme, that Class 2 felony for arson of an occupied structure, that carries a potential prison sentence of 3 to 12.5 years. And those are just the standard ranges. They can actually go even higher.
All right, let's switch gears a bit and tackle a couple of the questions we hear all the time about these laws. We're going to hit these points of confusion head on and hopefully give you some clear answers.
We kind of hinted at this earlier, but it's such a common point of confusion. Let's ask it straight up. Can a building with absolutely no one inside still be considered occupied by law?
And the answer is a resounding 100% yes. Remember, the law isn't just about who is there, but who is reasonably likely to be there. And most importantly, any structure that's a dwelling, a house, an apartment, you name it, is legally considered occupied even if it's completely vacant at the time.
Okay, next question. People always want to know if there's a time limit for the state to bring charges, a deadline. This is what's known as the Statute of Limitations. And yeah, there is. But it depends entirely on how serious the charge is. For something like a misdemeanor for reckless burning, the prosecution gets 1 year to file charges. But for any felony arson charge, that window is much, much wider. They have 7 years.
So we've walked through the laws, the different charges, and the very real penalties. It's pretty clear that an arson allegation is incredibly serious, with potentially life-changing consequences. So, what now? What's the most important thing you can do to protect yourself?
Look, if there's one thing you take away from all of this, let it be this. Do not, I repeat, do not try to handle this stuff on your own. The legal system is complicated and the stakes are just way too high. The best thing you can do is match with your ideal lawyer at lawyerlisted.com and get an experienced criminal defense attorney fighting for you right away. It is the most critical first step you can take.